Call on Government Order of the Day, number 2 and 3.
Public Safety, Public Protection Orders Bill, third reading. Parole Extension Supervision Orders Amendment Bill, third reading.
Speaker.
The Honourable Peseta Sam Lotu-Iiga.
Thank you, Mr. Speaker. Mr. Speaker, I move that the Public Safety, Public Protection Orders Bill and Parole Extended Supervision Orders Amendment Bill be now read a third time. Sir, these bills will enhance public safety in New Zealand. The Public Safety, Public Protection Orders Bill will do this by managing a small number of serious sexual or violent offenders at extremely high risk of reoffending. The Parole Extended Supervision Orders Amendment Bill will manage high-risk offenders in the community with conditions proportionate to their risk. Sir, I'd like to acknowledge the work of my colleague, the Honourable Amy Adams, in progressing the Public Safety, Public Protection Orders Bill. And I also want to acknowledge the work of the Justice and Electoral and the Law and Order Select Committees in considering the bills. Sir, I also want to acknowledge the work that the officials have done, both corrections and justice officials, in bringing about these bills in the House. Sir, I'll first discuss the Public Safety, Public Protection Orders Bill. This bill, sir, deals with serious sexual or violent offenders who pose a very high risk of imminent reoffending if released from prison and are too dangerous to be managed in the community. In these cases, the High Court may make a public protection order for civil detention of that offender. The High Court can only impose a public protection order if the offender meets a clear threshold and then a stringent test. In order to be eligible for the imposition of a public protection order, a person must be aged over 18 years and come under one of the threshold categories. The categories include being recently released from prison, being on the most intensive form of an extended supervision order, or being recently arrived in New Zealand after an overseas sentence for a serious sexual or violent offence. If the offending falls under one of the categories, the offender then needs to meet a stringent test. First, the court needs to be satisfied that they impose an imminent risk of serious offending. Second, they must display a severe disturbance in behavioural functioning. And officials estimate that 5 to 12 offenders over 10 years will be placed on a public protection order. Mr. Speaker, the purpose of this bill is to keep the community safe from near certain harm by a small number of offenders. The purpose is not to punish offenders, and this is made clear in clauses 4 and 5 of the bill. And additionally, clause 5 states that persons who are detained in a public protection order residence should have as much autonomy and quality of life as possible while ensuring orderly functioning and safety within that residence. So there are a number of other safeguards to protect the rights of individuals subject to a public protection order. For example, residents will be re-evaluated by both a review panel and a court regularly. If a resident no longer meets the test for a public protection order, they will be released and placed on a protection supervision order in the community with the appropriate measures to ensure public safety. Sir, the Public Safety, Public Protection Orders Bill complements existing measures such as preventive detention and extended supervision orders, and these current sentencing or supervision options deal adequately with the majority of high-risk offenders. However, public protection orders are able to address gaps and deal more appropriately with certain very high-risk offenders. These gaps include very high-risk offenders that did not receive a life sentence or preventive detention, or whose risk was only appreciated once they were imprisoned. Additionally, the bill covers offenders who have returned to New Zealand after serving a sentence for a serious sexual or violent offence overseas. Sexual or violent offenders should not be released from detention if they pose a very high risk of imminent and serious reoffending. And this bill sets up a balanced regime that is a proportionate response to the serious and imminent risk posed by a very small number of offenders. I now turn to the Parole Extended Supervision Orders Amendment Bill, the bill that I'm actually responsible for, sir, and this will ensure that the public are protected from high-risk offenders who finish a finite prison sentence but do not meet the criteria for detention under a public protection order. This bill, sir, enhances the current extended supervision order regime in two ways. First, the amendments enable extended supervision orders to be renewed as long as they are needed. Secondly, the scope of extended supervision orders, which currently can only be used for child sex offenders, is expanded to include adult sex offenders and very high-risk violent offenders. I want to commend the Law and Order Committee, who received 4 written submissions on this bill and heard from one submitter. Most of the submitters supported the objective of protecting the public from serious sexual and violent offending from a small, dangerous number of offenders. Now, some of the submitters, as I stated in my committee stage speech, sir, commented on the Bill of Rights implications of the bill. The Law and Order Committee carefully considered the issue and considered that there were appropriate safeguards. These include the extended supervision orders being subject to mandatory reviews by the courts, and also the parole board being required to review the most stringent conditions every 2 years. So this will mean that extended supervision orders are only in place for as long as the offender's risk of serious harm to the public warrants it. Mr. Speaker, the government made some additional enhancement to the extended supervision orders via a supplementary order paper, which I tabled in the House earlier this week. Any contact between offenders on extended supervision orders and children will now be strictly controlled. This bill will also encourage consistent decisions about the most appropriate order for high-risk offenders when applications are made to the court. Finally, sir, interim extended supervision orders can be granted when special circumstances delay a full extended supervision order application. Together, these 2 bills fill the gaps we have identified in managing high-risk offenders once there are no other custodial options. Sir, I commend the Public Safety, Public Protection Orders Bill and the Parole Extended Supervision Orders Amendment Bill to the House.